So today we're going to talk about campus community, and this will be a brief lecture that helps reinforce some of the reading that you had this past week. So this lecture is going to review and apply some legal issues of the housing requirements, and it's going to review legal issues of search and seizure, and we're going to talk about some of the legal issues of campus security versus law enforcement. So, in terms of housing regulations, there are a variety of different types of living requirements that an institution can put in place, and a lot of these are in the contract or in policies and procedures. Most institutions have some sort of mandatory housing where they require students to live on campus either their first or second year. They may also have first-year student housing where they separate first-year students from upper-class students. Same thing goes for upper-class housing. They may have non-married housing, or they may have housing based underneath a specific age. Now, whatever these policies are, they need to make sure that they're justifiable for educational purposes. So for example, if you have first-year students and you have upper-class students living together, there may not be an educational benefit for having these two populations together, but there could be an educational benefit for having these two populations apart. For example, for first-year students, you could tailor your programs that are focused to their developmental level. If you had upper-class students in that mix, it could cause some problems in terms of the educational benefit of the housing. Now, these policies have typically received challenges for students that want to live on campus versus students that want to live off campus. There have been challenges for first-year students that wanted to live with upper-class students that wanted to live off campus based on the mandatory housing policies, and most of the time, as long as there is an educational benefit and the institutions are very intentional, these challenges are not successful. Now, a lot of the challenges will happen because of the Equal Protection Clause. And essentially what they're saying is that these students are not necessarily getting equal living conditions or equal rights. So the policies need to make sure they're very clear in what they're trying to do. So for example, there was a policy on campus that said all 23-year-olds were exempt. Now the question became, why were 23-year-olds being treated differently than 21-year-olds? Okay, there's an equal protection there. So the court basically ruled because there is no good reason why the policy exists, then equal protection needed to apply. So the policy needed to be 21, which is the age of majority, or excuse me, which is the a federal age of drinking. That made sense, and the courts upheld that there was a reason for that application. Now, another piece of the equal protection is freedom of association, which means students have the right to associate with whomever they like in housing, and the same is true for the rights of privacy. Students living in housing have the right to privacy. Now, I mentioned the policies, and they need to be justifiable. So there needs to be a very good educational benefit to why these policies are in place. They cannot be arbitrary and capricious, such as the 23 versus 21. So giving blanket coverage to everybody that's 23 and over, as opposed to somebody that's 21, is a little arbitrary and capricious. It doesn't make sense. It's not justifiable. In terms of finance, excuse me, a lot of times housing policies will be based on finance and being able to make the notes. And this is okay so long as that they are consistent in enforcing the financial policies. So if they started changing the policies based on students who came from certain areas, that wouldn't be a justifiable policy. Now, if students had scholarships to supplement the housing income, that could be fine because they're being consistent, it's outside of their purview, it's not arbitrary and capricious, and it's certainly justifiable. And I mentioned the educational benefits, so as long as it adds to the educational mission of the institution and it takes into account the development of the student, there could be an argument for an educational benefit. Now, one big question is search and seizure, and this has a big part to do with the state action doctrine. So if we go back to that little continuum on where institutions fall on public involvement, so if they fall to the right where it's a strictly private institution, they have a campus security, then the ability for them to enter is strictly dependent upon their policies and procedures. But The Fourth Amendment protects individuals from illegal searches and seizures by law enforcement, by deputized, state-endorsed, statute-recognized law enforcement. Now, if it's in plain view, then police can enter a student's residence because it's the plain view doctrine. So if they see something legally happening, they can enter the residence. So for example, if there are windows and they see marijuana and other paraphernalia on a counter, they can then enter that residence because it's in plain view. Same thing for a vehicle and any other type of area. Now, there's a big question between law enforcement versus administrators entering a room. Okay, law enforcement needs a warrant anytime they want to enter a room. Administration can enter a room if they're enforcing institutional policies. And these policies typically indicate some sort of reservation of right, saying we reserve the right to enter your room in case of an extreme emergency, we will give you 48 hours notice, etc., etc. There's always typically some reason for administrators to enter a room. And that's so that they can protect themselves from negligence. And I'm going to talk about that in a bit. But the administrative policies cannot waive constitutional rights. So in the housing contract, it cannot say you waive your right for law enforcement to enter your room at whatever reason. That cannot happen because you are waiving your constitutional right, your Fourth Amendment protection for illegal searches and seizures. Now in the contracts, they need to be narrowly tailored and they need to be least burdensome as possible in order to allow administrators unfettered access to the rooms. And in fact, a lot of times they don't get unfettered access because there is that right to privacy. So there needs to be a reason for entering. There needs to be something in the contract that indicates that people will be entering this room, whether it's for maintenance, it's for emergency, it's for health and safety inspections. And if there is a conduct reason to enter a room for search and seizure, oftentimes it is either in the contract or is referred is in the contract and referring to another student policy, maybe a blanket thing that says the students are expected to uphold all conduct, etc., etc. Now, in terms of campus security, public institutions are typically provided with deputized law enforcement. Now, this may not always be the case, but oftentimes if it's a public institution funded by the state or the federal government, there is some sort of police, whether they're considered state troopers, local law enforcement, or whatever it may be. Now, they may have security officers that work in conjunction with the police, and these security officers don't have the full capacity as an actual law enforcement officer. They may be there to provide support or do other things that may be needed. Where we start getting really sticky is with the state action doctrine and private institutions. So if you have a private institution that has a public enforcement, public law enforcement, then the involvement of that public law enforcement will start to shift that continuum on the state action doctrine. So if you have a private institution with public law enforcement, then there's some open records that happen there despite being a private institution. Because of the preemptive doctrine, we know that the rights of law enforcement are protected by the state, because the state is the ones that gives them power, not the private institution. So they're acting as a state, so they're a state actor. Now, campus security is typically on campus for the sole purpose of protecting its students. That is an expectation that falls under negligence. An institution has a duty to protect their students, a duty to warn them in case of an emergency, for them to take due care, to provide notice, and if there's any foreseeable danger that could happen. And all of this is really enforced in the contracts, both implied and explicit. In terms of the duty to protect, institutions have a duty, an obligation, legally and morally, to protect their students from danger. So for example, if we have a residence hall and it's known that people outside the institution can get into that residence hall and they can provide a dangerous environment to students, if the institution does not act, they can be negligent because there is that duty to protect their students. They also have a duty to warn their students in the event of danger. So if there's an active shooter and they take no action to warn their students, then they can be held negligible and liable for damages. And a lot of this started evolving out of the Virginia Tech case because of their lack to warn students of the dangers. Now, due care is when an institution or an individual is able to exercise in a particular situation by looking out for the safety of others. So in other words, if a reasonable person, man or woman, can foresee some type of danger and somebody doesn't take action by what a reasonable person would do, then they can have a negligent situation on their hands. So essentially, due care is a person taking reasonable action to correct a situation. Now, what is reasonable? That depends on the jury, and it depends on how it's argued. And that is very important because if you have a good faith effort, you make an effort to try to correct a situation, then you are taking due care. In terms of notice, being able to provide notice of a situation is very similar to duty to warn. And foreseeability, if a reasonable person can foresee some sort of dangerous situation and the institution doesn't take action to correct that situation, they can be held negligible. So an example of that is when I talked in class about the hill at the University of Tennessee and there wasn't a fence. A reasonable person could assume that somebody could fall down that hill and get hurt. So by not putting up a fence at that time when somebody fell down, they could be held negligible for that situation. And all of this, like I said, is typically covered in contracts. And if there is a breach of some sort of promise to student safety or campus security, then they can also be held negligible as well. Now, that covers the campus community. I'm going to provide a discussion post that's actually like a mini case study to help you apply some of these concepts and some of the reading that we talked about. So I'll be posting that now. Thank you.